Welcome, everybody who I know some people are still coming in. Welcome, everybody who I know some people are still coming in, but we are going to get started. Welcome to Ethical Considerations for Lawyers Using Generative AI and Delivering Legal Services. Today, we'll be talking about, let's get started with some introductions. As mentioned, I'm Jerry Levine and General Counsel and Chief Evangelist of ContractPodAi. Lindsay, can we jump ahead to the slide? Or there we go. General Chief Evangelist and General Counsel at ContractPodAi. We are a legal technology company that works with AI solutions and legal language and models that we've developed to assist lawyers in-house and outside counsel with their needs across the entire business. James? You're muted, James.
Sure. Thanks, Jerry. Happy to be here. Welcome, everybody. My name is James Gatto. I founded and I'm a team leader for the AI team at Sheppard Mullin. We have about 100 and something and growing lawyers on our AI team, one of the largest and fastest growing industry teams in our firm. We really provide comprehensive AI advice to clients across all industries. I personally have been involved with AI for over 20 years, teach a law school class on AI legal issues and involved a number of different bars and other AI-related associations.
Let's get started then. Apparently, we're both going to struggle with the mute button today. Today, we are going to cover as much as we can in this hour and with reading as few slides as possible. So we're going to start with some overview of what we're talking about, generative AI and ethical concerns, get into some of the existing ethical obligations, talk a little bit about fact-checking, litigation issues, and then unauthorized practice of law. I do want to draw your attention to this news clipping on the right side of the screen. It's from a recent British Lord Justice Pierce said ChatGPT and other AI programs had great potential. And he talks about summarization, but the key thing Justice Pierce says is that he takes full responsibility for what the AI did. And I think that's going to be a key thing we're going to keep talking about throughout the entire day, throughout this entire session, is why it's important to be responsible for these AIs. They're really something that I like to call, I like to think of AI as augmented intelligence, not artificial intelligence or alternative intelligence, but really something that makes you a better lawyer, a better practitioner, and ultimately, remember, it's your job to supervise it. So let's keep going. Why are we doing this? You got these two things on the screen, one from Thomson Reuters, one from LexisNexis. I am certain you're all familiar with them. But effectively, what we've found already from these surveys is that 67% of respondents, and everybody here who's a respondent is a lawyer, is thinking that AI will have a huge impact on the profession. You know, in LexisNexis's survey, it was even higher. That's 92% of lawyers said it's going to have some impact or significant impact, but 88% thought it's going to have some ethical concerns about the use of generative AI. So let's go on and let's get a little bit into why generative AI creates ethical concerns. And for those of you who may not exactly know what it is yet, although you probably heard of it, we'll touch on what generative AI is. By the way, I do want to invite you, I don't think we mentioned this earlier, but if you do have questions, please do click the Q&A button at the bottom of the screen. They will pop up for Jim and I, and we will be more than happy to answer them either live at the end of the session. If it's really interesting, maybe we'll start talking about them in the middle of the session, or if we can answer them by typing, we'll do our best. So let's talk about what generative AI is. You heard me mention augmented intelligence, but AI, when we typically talk about it, we mean artificial intelligence. I just like to think of it a little differently because that's how I use it. We mainly talk about it when talking about machine learning. That's how computers learn. They can do things, whether you've taken a picture of a leaf with your phone to ask, what tree is this from? Or if you've uploaded, or if you've already touched something like ChatGPT, Google's Bard, or other tools to ask questions or have it try creating text for you, that's something that can happen. What generative AI is, it's using algorithms to generate, I mean, it's pretty straightforward, to generate new text, images, and more. This is based on artificial language, artificial neural networks, large language models, but no Pokemon. And that's because the reason I put that in there is some of the tools have very strange names. Whether you've seen some of them, there's Mistrals, there's Happy Face, Hugging Face, different things that you might think are a little strange sounding. But in the end, what we do with generative AI is we've used existing text, existing knowledge to teach an AI how to create something new and or at least get to something new there. So we'll go on to the next slide and we'll talk a little bit about this. So let's think about what the big thing is here and what really brought this to everyone's attention. So a couple years ago, probably last year, you started hearing about something called Dolly that was making pictures of itself. You heard a little bit about something called GPT-3. And what these are what are called large language models. They're huge data sets where basically we've created artificial brains, as close as we can say. Those are artificial neural networks, and they've got billions and billions of parameters. What the parameters are all those things that that artificial neural network has been taught. There's a key thing, though, that you have to think about with this is although these large language models, these generative AI models can create text, videos, pictures, sound, and they seem human in their responses, they're actually not. One thing that I point out is they don't interpret things. That's why we're lawyers. We interpret things, we make decisions. What are they really? They're giant autocorrect machines that don't actually understand or know anything. And I say this because if you took your phone and you just kept hitting autocorrect and selecting the next word, that's basically the same thing that ChatGPT, Bard, other models are doing. And so really one way to think about it is these LLMs, they don't know who George Washington is if you're talking about the first president. But what they do know is that the word George Washington is probably followed by the first president of the United States of America. So they look at similarity, they look at different ways things can connect together, and then they draw those connections. Now, again, they're really good at it, but that doesn't mean they're perfect. They're constantly being improved. They're constantly getting new input, which is why you've heard about all these problems about training, about data being put in that's confidential. And we will get to that in a little bit. But basically, they are they are there and they're a very, very powerful autocorrect that can tell you a little bit about what you're doing, but you've got to train them. You've heard of prompting, and that's what that is. Those prompts that people write, like write me a poem, a Shakespearean poem, but as though Cookie Monster wrote it. That's the prompt. And the LLM, the large language model, the AI, is going and saying, well, Cookie Monster sounds like me want cookie, yum, yum, yum. And Shakespeare sounds like, well, I'm not going to try to quote Shakespeare right now, but, and we'll, a little later, I think I do, though, don't I, Jim? When I talk about kill all the lawyers. Um, that's really what they're doing. They know what Shakespeare sounds like, they know what Cookie Monster sounds like. So they just kind of mesh them together and give output that you think you would like. So I went through a few cautions there, but let's go to some more cautions with these large language models and AI. And by the way, I do want to point out, as the general counsel of an AI company that sells tools like this, there's a reason we talk about untrained and untaught AIs like these and specialized AIs like Arlia at ContractPodAi or other ones you've heard of that are really trained to do specific tasks, whether they're legal, medical or otherwise. So what are some other cautions? Incomplete or inaccurate data. Now, you might have heard ChatGPT, for example, cut off in September 2021. They've only just announced this week or last that they've gone beyond that. You've heard of hallucinations. That's when the AI makes something up. We'll talk a little bit about the case a few weeks ago, or a few months ago now, where the AI made up court cases and would just, the lawyer submitted them and was sanctioned. Harmful information. We hear a lot about that. If you've been paying any attention, and I will admit that I am extremely online, but Meta, Facebook released a generative AI sticker creator yesterday or the day before. And one issue that they're already facing with that is people have been able to generate pictures of, uh, Muppets flying planes in the World Trade Center in 2001, or, Sesame Street characters holding guns. So there's a lot that still has to be done there. You've also got the problem with AI bias, which is, we'll talk a little bit about this later as well, but that's the fact that the AI is trained on what we've gone through as humans. So humans, we do have biases, and it takes large teams of specialized scientists and cultural experts and folks to really get that AI bias out of there. Another issue is transparency and consistency. The AIs are not always as consistent or as transparent as you want. So we do have 3 sessions on this, and one thing we'll talk about, I think, in the vendor session, I think that's the third of these 3 panels, will be, things you want to ask vendors, things you want to understand. Finally, you've got confidentiality of inputs, license grants to platforms, and indemnities platforms. If you've looked at the terms, and we'll show you a screenshot of one of them, you might see, especially in these public models like Bard, like ChatGPT, they tell you nothing's confidential. Anything you give them, they can use, and that they have no liability for it. So, I see we are starting to get questions. Jim, do you want to start? Should we answer these at the end, or do you want to answer them while in the middle of the session? It's really up to you.
We can look at them as they come along, and if there's something we're going to cover later, maybe we can wait on them. If it's something that's timely to what we're talking about, why don't we address them?
Okay.
As they come up.
Great. So I think you're about to jump up, and we're going to talk about competency and confidentiality. So let's talk about this question we just got as we get to that.
Sounds good.
Awesome.
Great. So thanks for that great introduction, Jerry. We're going to talk now about some of the ethical obligations when lawyers are using these tools, and there's many, and we're covering a number of topics that may not all be relevant with every tool or every use, but here's some of the ones you may want to at least make sure you think about as you use these tools in your practice. So one of the first is the duty of competency. So the ABA model rule has stated for quite some time that attorneys must represent their clients competently. This has been kind of updated to include specific coverage to understand the risk and benefits of technologies that are being used. This was comment 8 to the rules. And this requires lawyers to stay abreast of changes in not just the law and its practice, but with respect to relevant technologies. And there's been a couple of decisions in New York and California that are kind of identified here on certain aspects of technology that courts have addressed, or the opinions have addressed. And we're seeing more states beginning to require specific technology training for lawyers. I think kind of the key takeaway here with respect to generative AI, well, this applies to everything, but particularly with generative AI, as we're talking about today, is that lawyers need to understand the technology they're using. And that's easier said than done. A lot of these tools are changing quite rapidly. Many of these tools have different features that they're introducing, some of which provide greater safety, if you will, or features that help mitigate some of the potential legal and ethical risks. We'll talk about a few of these today as we go through. And I think one of the things, and this applies to a couple of the other rules we'll talk about, but just to kind of say this up front, is that some law firms are prohibiting attorneys from using AI tools, and that's certainly a safe approach. But on the other hand, it doesn't enable the efficiencies that AI provides. And so for companies that have kind of dug in on this, and law firms have dug in on this, rather than ban these technologies, by understanding what they are, understanding the terms of use, understanding the use cases that are relatively safer versus ones that are riskier, by developing policies, you can effectively manage safe use of AI tools by lawyers. And so it really comes down to vetting the tools and particularly the terms of use. We'll talk, as Jerry mentioned earlier, when we get to the confidentiality, it's critical to understand some of these tools, the inputs you provide are not confidential. We'll talk about that some more. But I do think that policies are important. Our firm has developed one. We have in addition to the AI industry team that we have for serving clients, we have an AI policy team within the firm, and we involve our IT folks. They will assess security issues and technical issues, and we have lawyers as well on the team that look at some of the legal issues with terms of service and other factors. Okay, next slide here. Okay. Duty to maintain confidentiality is a well-known requirement by attorneys. You generally cannot disclose client confidential information unless they give you specific consent. If there's, in some cases, if there's disclosure is authorized by implication or otherwise, or where disclosure is required, for example, pursuant to a court order. With respect to generative AI, Jerry mentioned earlier ChatGPT, for example. This is an example, I think, of where understanding the terms of use is important, but also understanding that even for the same tool, you can have different features of that tool that provide different results. And so what do I mean by that? So with ChatGPT, there's an enterprise version and there's an individual user version. If you sign up for the enterprise version, you can access the service through an API, whereas if you use the individual version, you're typically accessing it directly via the web or mobile app. And one example of the difference of those different versions and those different methods of access is that the ChatGPT terms distinguish between those two and how they treat your information. So as indicated here on the left, they state in the terms that they will not use your content that you provide if it's via API to develop or improve their services. So they're not going to take your inputs and train their models on that. But if you access it otherwise, so if it's non-API, they will. So there's an example of understanding a feature of the tool that can shift the risk profile based on which version you go with. And on the right, you see the barred privacy notice that I won't read the whole thing, it was kind of there more for reference, but you can see that they kind of treat things a little bit differently. And they kind of highlight at the end, do not include information that can be used to identify you or others in barred conversations. So in addition to confidential information, in some cases you have to deal with, of course, privacy-related information as well. So I think the question that kind of popped up kind of relates to this. Let me kind of address it. So the question is, it relates to the fact that the ChatGPT data set had a cutoff for the training data of 2021. So the question is, how does what I input get used such that it is no longer confidential? The ChatGPT 3.5, up until the recent versions, were trained on data with the cutoff of 2021. Newer versions will use information that it can be trained on after that date. So I think the short answer is that while it may not show up in the earlier versions, it may show up in the later versions. I don't know, Jer, if you have anything you want to add to that.
Yeah, one thing I would add, thanks, Jim, is that keep in mind that the training data is also different than the data you input. So although that let's say you have, and this is going to make me sound very old, if you have an encyclopedia, the encyclopedia is only current as the data was printed. For those of you who've never seen an encyclopedia, it was a set of books that you used to get as a kid, and it would sit on the shelf, and you would never use it except when you had a school report due. Um, but the training data the new data that you put in was being added to the data set, even though it wasn't being trained on it. It was being taken in and added to the knowledge and the education. So if you put something in and then asked a question about that new information, ChatGPT, for example, could use the information that was put in, and it didn't matter if it was your information or somebody else's. So, the training data is, if you remember back, sorry, Jim, I know I'll get off of this in a second. If you remember back to the very beginning, when I said, when we were talking about uh, the the parameters that were used, the billions and millions, that's that training data. But beyond that, what was being added is all the data people were putting in, whether they knew it or not.
Great. Thanks, Jerry. So another aspect of confidentiality that is important, I think will become even more important going forward, is, and this also relates to understanding the features of some of these tools, is that there's this concept called fine tuning. So one of the nice things about these large language models, these third-party tools that everyone's using, is that they're trained on all kinds of information. They're not trained for specific purposes or typically trained on specific legal problems or industries, et cetera, right? That's why they're called general AI, or the large language models are just kind of general information, very comprehensive. And so one of the advantages of that is you can put a request in for any, or an input for any topic, and it'll be able to provide some level of response to you. But what we're seeing, and what we'll see more of, is this concept of fine tuning. And fine tuning enables you to use some of your own data with kind of alongside the LLMs to get a more customized result. So in ChatGPT 3.5, there was a recent announcement, which is kind of linked here, and you can read about that if you want more information. But a way this relates to lawyers, for example, is you can ask ChatGPT currently to write a brief on a particular topic. You can put like an outline of issues in, and it'll come back with a legal memo or whatever you ask it to write. You can ask it to do an agreement, and it'll get you an agreement based on the parameters you put in. And that's all fine and good. But what's better is if you can use your own existing briefs, memos, agreements alongside of these tools. And what it'll do is it will actually kind of customize it based on your preferences, your style, or other parameters in the documents you've historically used. And so part of this involves a level of training with respect to your existing content. You want to make sure that if you're using information like that you're not including any confidential information. Some of these tools that they operate in different ways. In some cases, your information will not get into the general data set that's used to train these models. You need to understand that though on a case-by-case basis, where that's the case and where it's not. But this is a powerful tool, but if you're going to do that, you need to make sure that the information you're using doesn't create any problems. Okay, the next topic, oops, skip one here, with respect to confidentiality, is really to understand some of the key issues. And we've touched on some of these, but just to kind of summarize, you really need to understand how the tool works, what it does with the inputs. You need to read the terms to understand what the the terms say about how the tool will operate. For some of these tools, you're actually granting an express license of your input to the tool company. You may or may not have a right to do it, depending on what the information is that you input. There's different level of security with these different technologies. You should undertake a security assessment. You take other precautions with respect to security and confidentiality, depending on the use cases. You want to be careful about the information you put in. You need to avoid, obviously, any inadvertent disclosure of privilege type information if what you're putting in relates to that. And even if you've done an assessment, you think a tool is reasonably safe, obviously client instructions trump that. So if a client says you cannot use generative AI, and some clients have come out and say that, you need to do what your clients tell you. Okay, Jerry's going to cover some additional topics with cybersecurity. Jerry, please take it away.
So this is really important, and I'm a New York attorney, and New York now requires CLEs on cybersecurity. And part of this is because attorneys are not always known as the most tech-savvy folks on the planet. Some of us are, some of us are not. So but all running throughout all of this is attorneys need to make reasonable efforts to protect client information from unauthorized access, including cyber attacks. So what are some of the things that have gone on? And, that you only should have authorized parties able to access information. Attorneys they must take reasonable steps to prevent and detect data breaches. So if you see something, again, New Yorkers here will know, and everybody will know, if you see something, say something. And finally, as Jim was saying, lawyers and firms should only use AI tools that they've analyzed and deemed safe. Like I said at the beginning, I'm at a legal AI firm. Our tool is Leah, has been designed to do exactly what Jim was saying a few minutes ago, where the training set is different from the data set that the lawyers can work with it in. And again, going back to this, there have been a number of recent issues. Engineers at a large company were uploading confidential information into ChatGPT, which unfortunately is now part of the GPT-4 data set. So going back to that question from earlier, as Jim was saying, they put it in and their confidential information became part of the new data set. And really, one of the things you need to think of is, unless you can be sure that no one can access it without permission, you need to make sure that you don't use something that lets other folks potentially access that information. As Jim said again in the prior slide, one item is developers and providers of these tools are constantly now developing ways to keep information separate, to keep confidential proprietary information, client information outside in a separate bucket from that of the actual generative AI processing information. And even cooler now is we've got some new generative AI large language models that can run entirely in a company's, law firms, or providers' data space without going outside of that. So I think that's another way you're seeing it. But of course, you want to ask these questions. How do you control my data? How do you do this? What is going to be shared to the outside? Is it kept and deleted? Jim.
Great. Thanks, Jerry. Okay, so the next topic we want to talk about is another duty that lawyers have, and that is the duty of supervision. So again, probably all familiar with the general rule that attorneys have a duty to supervise allied professionals. This includes paralegals and other staff. We used to think it just applied to legal assistants, et cetera. It certainly does. But when you're using AI as a tool, while it is not necessarily a professional, you still need to supervise the output. It is important, as Jerry mentioned, to understand that you can't just necessarily rely on the output of an AI tool without separately reviewing it, ensuring its accuracy, completeness, et cetera. there's cases. There was Jerry kind of touched on or alluded to a case where lawyers used an AI tool. The tool made up some cases. The lawyers were smart enough to ask for citations to the cases, as any good lawyer would, but unfortunately it relied on the same tool that lied about the case, and the tool made up citations, and the lawyer submitted the brief and suffered the consequences. So you don't want to do that. It's important, as Jerry mentioned earlier, some of the cautions with AI is that while these are very useful tools, and while they often provide very helpful and in many cases accurate results, it's not always the case. So you need to be aware of that and ensure that you, as you mentioned earlier, take responsibility for the outputs and do any independent research as necessary. One of the other areas, or two of the other areas to think about, is the duty of communication and the reasonableness of fees. So Model Rule 1.4 governs a lawyer's duty to communicate with clients and consult with clients about how clients' objectives are going to be accomplished. Well, there's not necessarily specific guidance yet that I've seen on how this relates to AI. As I mentioned, I know some clients have specifically prohibited the use of generative AI. It's probably good to talk about this with your clients and have conversations about it, both from the standpoint of making sure they understand what you're doing and making sure they don't have concerns about it. But also what we're going to see more of is having a conversation about the reasonableness of lawyers' fees. If you're doing a straight hourly rate, for example, for a particular matter or a particular client, and you're getting great efficiency because of generative AI, well, that's great. That's going to all inure to the benefit of the client, and that may be fine. But over time, as firms invest more in these technologies and there's greater cost savings, it may be appropriate to find some way to share the value of that and have conversation with your clients about alternative billing in ways in which there can be more of a kind of a win-win or a sharing of the cost savings, so that clients get greater efficiency out of the legal work that's being done, and lawyers can benefit from the investments that they're making in these technologies. They're not free, so they do add value, but I think this is an area that people will need to focus on as well going forward. This is one that can arise in some situations. There's Model Rule 8.4G prohibits harassment and discrimination by lawyers. In most cases, lawyers aren't going to use AI tools specifically for this purpose. Potential some may. But it's important to understand, as Jerry, I think, mentioned earlier, some of the data sets that are used to train these tools include bias-based information. It's not an intent to train these models in a biased way. It's really more due to a lack of foresight to ensure that there is not biased data. And bias can arise in a number of different ways. There's some kind of well-publicized situations of companies that used AI to screen job applicants for particular jobs. In some cases, the tools were trained on kind of the resumes of prior people who held the positions for that job. And it turned out, at least in one case, that pretty much all of the prior people who held those positions were white males. And the tool screened out and didn't give interviews to anyone who was not a white male. So that's an example of where the existing facts and the existing data led to a bad result. There's a lot of ways in which AI can lead to bias and discrimination, where the data is not representative of the class of people who will be using or to which the information is relevant. Many examples along those lines. If you are interested in that topic and haven't watched it, there's an excellent documentary by PBS called Coded Bias. And it walks through a number of scenarios where there is actual situations where bias or discrimination has resulted from some of these tools. And it's
Jim,
really fascinating and eye-opening.
we'll show one in a second, in fact.
Indeed. So, there's kind of 2 points to take away here. One is, you don't want to intentionally use these tools in a way that would create harassment or discrimination. That's probably the lesser concern for pretty much everyone listening today. But I think it's important to understand that some of these tools may actually have bias or discriminatory results that come out of it, and you need to be mindful of that and ensure that you don't do anything that would propagate that type of information. Okay, and Sherry's going to take the next topic here.
Sure. So let's talk a little bit about fact checking and what can go wrong. And the reason we want to talk about this is because of a number of the things Jim just said. So why is it necessary beyond beyond the model rules, beyond the rules that apply in your jurisdiction that we're all doing? Remember, LLMs can create entirely authoritative sounding text, but really just predictive text generators. If you ask I can ask a ChatGPT, and the reason, by the way, I define the public models and the publicly accessible versus the private and business models that people are developing is because some of these items are being addressed in the private models, the ones that are not accessible to everyone in the world, or they're being set up in different ways, like the APIs, the application programming interfaces Jim talked about earlier. These models can create very, very real sounding, very, very true sounding text images that don't actually exist. So I think a little bit we'll talk about deep fakes and other made up topics, but you have to be aware of the fact that what it can tell you may not really be what's actually real. AIs also can't exercise decisions. They can't make decisions. They can't make judgment. And there's a wonderful poster that I just thought of that used to hang in IBM's offices that a computer can never make managerial decisions because a computer can never be held responsible. You can, in other words, you can fire a person for a bad decision, but you can't ever really do anything to a computer. You shut it off, it doesn't care. It's not going to sit there and cry, "Oh no, please don't pull my plug. Won't do it again." It's just going to make the same decision over and over. We talked about the recent case, Mata versus Avianca. That attorney there went and said, ChatGPT, I need you to write a brief for me about this topic, gave the topic, made up the cases, and then the attorney didn't even check the cases. As Jim said a moment ago, he said, are these real cases? And I am summarizing a little, but are these real cases? GPT came back and said yes, and the attorney submitted it to the court. Not a single thing in that court case that those cases was real, although they all sounded real. They all came from the text was all predicted based on real court cases. None of them were actually existing or exist. None of them were existing cases. None of it was existing case law. That's why I keep saying, when you look at these tools, look at things that are specialized, where the developers, the companies that are providing them, are actually working on legal AI models. They're thinking about these things. We're trying to make it more secure and safe to use for the industry we're in. We also just talked a little bit about bias. And Jim, do you still have control?
There we go.
There we go. Again, AIs, large language models, all of these generative AIs are only as good as the data used for training. So you see here on the right, BuzzFeed did, when the Barbie movie came out a couple months ago, asked a Midjourney, a generative AI art creation program, to generate Barbies for every country on Earth. And, people went wild after they came out because they were effectively all stereotypes. The one here is a picture of the Barbie it made for South Sudan, which has a gun. And you know, it's basically because the training set of data that Midjourney used said all the people in this country have guns. Everybody carries a gun around all the time. They dress like this, they look like this. So Midjourney said that must be what to use. So it's not just making sure the output is good, but also being aware of how it interprets and generates the output. You heard me mention a little earlier the concept of prompting. Well, there's a difference between when you're talking to these generative AI solutions, these products, what you ask coming in, the input, generates and drives the output. So if you say, generate something, make me a dad joke about llamas, it's going to come back with a dad joke about llamas. But if you say, make me a dad joke that is 3 paragraphs long, involves llamas and peanut cake. I'm really making stuff up here. But the more you give it, the more direct it will attempt to create that issue. Similar issues could arise in the practice of law. If you are sitting there and ask an AI, for example, again, we're picking a lot on ChatGPT, but that's because people know exactly what it is, and it's the most well-known version at this point, most well-known type of generative AI. If you said draft a set of bylaws, it's going to pull maybe some stuff from Edgar, maybe some stuff from corporate bylaws that have been posted on the internet. But if you said generate bylaws for a Black-owned company, you might actually see some of that bias come in. You might see different words being used in the bylaws, or ChatGPT may come up with unintentional but direct bias in there. So when you're thinking about these programs, you do have to supervise, you do have to pay attention to this, and you have to think not only about how you interact with it, but how the output comes out, especially in these public models. Jim.
Great. So we're gonna shift on now to the next topic and talk about how courts are addressing AI issues. Jerry just talked about the Avianca case. I think that's really one of the things that led courts to start thinking about this. And I think a lot of judges and their staff are also, like many people, still getting up to speed on some of these tools, some of the risks of using it. Despite the quote from Lord Justice Burst that Jerry put at the beginning about how jolly useful these tools may be, I think courts are pretty much taking the approach that lawyers are responsible for their use to the extent it's permitted. So, again, the types of things you want to think about, and where some of the courts are, kind of the direction they're going. If we try to summarize what people are doing, is you can use it to augment your work, not to replace it. So you can use it in different aspects of drafting and things like that, research. But the lawyers still need to be responsible and do all the other things lawyers will do with that as just another assistive tool. One of the big things that we're seeing is that what's interesting, we'll talk about this a little bit more in the next segment, which is the unauthorized practice of law, is really the balance between the ability to use AI as a tool to assist, particularly those who are unable to, afford, expensive legal service. And there's a lot of tools that are being developed, to assist in that regard, to provide greater access to justice. But there's some concerns about those, and we'll touch on with respect to when they, cross over into the unauthorized practice of law, which is another kind of hot topic. But, what some of the courts are doing right now is they're using AI tools. Like in criminal cases, for example, there's been a fair amount of use of AI in connection with bail and sentencing. And again, it can provide useful information on, the assessment of whether bail should be granted and kind of the right amount. There's also, in connection with sentencing, the use of AI to detect the likelihood of recidivism as part of the sentencing. And those are, in many cases, useful tools. The problem is, in some cases, they've produced biased results. And so their use is coming under greater scrutiny, and I think courts are taking a more cautious approach. I think some of the tools that have been marketed, while they have beneficial aspects to them, some of the data has turned out to show biased results. So I think there's going to be a continued balancing of trying to use it, but probably a little more caution in making sure the tools are safe. One of the other big issues is going to be evidentiary issues with AI. There's various rules of evidence that may impact when people try to submit evidence that is based on either an AI analysis or generative AI. There's obviously various different rules that are kind of referenced here. I won't go into those in detail. But certainly, these are things that courts will be grappling with and developing further guidance on as time goes on. There's issues already with the use of AI to provide so-called expert advice. Obviously, judges need to consider whether it's reliable information, including under the federal rules and some of the key cases like Daubert and Crawford, et cetera, where you would otherwise evaluate expert advice and whether it's admissible or not. And another big area is deepfake. So one of the great things about generative AI is it can create new content. Unfortunately, sometimes what it does is creating content that is inaccurate, misleading, or completely false. And I think we'll see this arise in many situations. We're already hearing a lot of concerns about the use of generative AI to influence elections, and information that will be put out in connection with the upcoming elections. We're also going to see this throughout many other aspects of day-to-day life. And the ability to rely on things we see in the press or other documents or images that are created is going to require greater scrutiny because of the rise of deepfakes.
Jim, I was going to say, I don't know if anybody else saw it, but Tom Hanks this past weekend had to put out an announcement that he was not, in fact, advertising dental services or dental health plans. It was completely faked. It was an AI generated image, sounded like him, looked like him, act like him. But he had to come out and say, not me. I did not condone this. So it is something where it's going to be hard for folks, and we're going to have to be prepared to know whether we can actually trust what we see.
Yeah. And Jerry mentioned, images. So we see a lot of fake images. We've seen, celebrities put on porn star bodies and, other things like that. But the other area that Jerry actually touched on in his last answer was voice. So voice prints are an area that are going to be particularly problematic. There's if someone gets a recording of your voice using generative AI, they can largely create you saying anything they want you to say in your voice, and it'll sound just like you. And so you're going to have interviews of people saying things that there's just not them saying it, but it's going to look incredibly believable. And as people try to introduce that into evidence, courts are going to have to grapple with those types of issues. Okay, so in the little bit of time we have left here, the last topic we're going to talk about is the unauthorized practice of law. And you would think that as lawyers, one of the easiest questions we should be able to answer and to agree on is, what does it mean to practice law? Well, it turns out that's not really an easy question. And so, of course, when you're talking about the unauthorized practice of law, you need to kind of first understand what is the practice of law. And it turns out that it varies by state. If anyone wants to really dig in, if you look, for example, at LegalZoom had lawsuits in a number of different states, and some of the outcomes were different based on the definition of practice of law in those states. Some of the states actually amended their laws to define practice of law differently, in part as a result of some of those cases. But if we try to summarize without this being 100% precise, Generally, if we give legal advice, if you represent clients in court, or if you're preparing legal documents for others, those are types of things that are commonly within the ambit of practice of law. But even that, there's some questions. For example, on the preparing legal documents, there's a number of cases. It depends on, is it just a straight up form that's like a government form that you're just putting information into, or does completing the legal document require you're making legal decisions, or kind of providing legal advice on parts of the form, to select which might be applicable or not. If that involves a legal decision, there's a number of cases that kind of get into that topic. So that's kind of a nuanced area. But the key thing to take away here is that while AI can be very assistive, and again, we talked about access to justice, there's a lot of people coming out with tools that are AI based to assist in helping people get legal information. Those are generally fine, but when the tool crosses over from giving legal information to giving legal advice, that's where these issues get implicated. And in fact, there is some that we'll look at one in a second, in particular that was purporting to give advice to people actually while they were in court in real time. And so just to look at a couple of examples. So one of the ones that's been in the news recently is this company called ClaimCam. What they've done is they've used AI to identify class members in class action lawsuits, and they take a 15% cut. Their tool has been used in some of these big cases, the Facebook, the Cambridge Analytica case, and the Jewel case. And the kind of the issue there is that there's the plaintiffs' attorneys are alleging that they're interfering with settlement administration, and they're making claims on behalf of class members who either don't exist or don't even know their rights are being asserted by third parties. Whereas ClaimCam, basically is taking the position that they're just helping to identify members and assist them with making settlement claims. Those issues are still kind of being worked out, but whether that crosses over the line of unauthorized practice of law, we'll see. But the one I mentioned earlier that dealt with in-court advice, they announced they were doing this, but the moment they announced it, they never actually got used, to my knowledge, in court. There was this company called Do Not Pay, which advertised a kind of a robot lawyer application, and it was a set of glasses with a video camera and speakers. And basically, it was initially designed for use in traffic court for people who were going in and arguing on their own. But it would provide this kind of real-time feed and would kind of tell people in real time what they should respond or what arguments they should make to fight their traffic ticket. So that was announced, but they never actually launched it for that purpose. They've kind of repurposed the company to do other things. But it's just an example of the type of things you can do with AI from a technical perspective, but maybe not from a legal perspective. There's a lot of AI legal chatbots. Again, a lot of those can provide useful information, but you don't, you can't cross the line and offer legal advice with those. I mentioned a little bit about, forms. This has been an area where there's been a fair amount of litigation. Some of the LegalZoom cases, another company called Upsolve. Again, there's a fine line between just kind of assisting people with filling out a form with factual information versus providing legal advice. And in some cases, creating the form itself, that you provide to users, if the form has certain, if it addresses certain legal issues that falls into the scope of providing legal advice, that in itself can be unauthorized practice of law if it's not done by a lawyer. The other thing that lawyers need to understand is that in some situations, if lawyers assist with applications that are found to be unauthorized practice of law, they themselves may be liable for contributing to that. So there was one company where they provided like a packaged legal service, and they completed forms for for the people who subscribed. And as part of the service, they had a lawyer review kind of the completed forms. And in that case, it was found to be unauthorized practice of law because in something like 1,300 instances where the form was completed, the lawyer only changed anything 3 times. And based on the relative amount of money that was going to the form company versus the lawyer, it looked like it was, not really lawyer review that was going on, and the bulk of it was basically providing advice through the technology side of the business. So there are situations where lawyers can be held liable in connection with schemes like that. Some of the tools that we've talked about forbid usage of their tools for legal purposes except by practicing attorneys. That's probably a good rule of thumb anyhow. And the FTC has issued a warning to legal tech companies about the fact that certain services can cross over into unauthorized practice of law. There's been a number of situations where consumers have complained about getting bad or incomplete legal advice based on some of these AI tools. So there's a link there to the FTC opinion. That is all we have. We have we can almost time this perfectly. We have 2 minutes left. We have time for questions. Thank you all for joining in today. We have 2 more. This is a kind of a 3-part series, so we have 2 more of these coming up. I hope you can join for those as well. Thank you all very much.